Hi, I'm Janice Switlo, and today I want to discuss more thoroughly Indigenous title, underlying title. Now I'm going to quote from an article that a professor at Osgoode Hall Law School wrote in 2018. Now I caution about the whole of the article because there are some distinctions here. Without getting too confusing about it, I just want to front end that I see Indigenous nations with original underlying title. I call that, or I'll usually refer to ownership by Indigenous nations. Formerly, I may have used in writings like 30 years ago, Aboriginal title. I don't use that anymore because of the Section 35 doctrine. Aboriginal title is actually technically the Aboriginal right of Aboriginal title, which is a defined term under Section 35 domestic doctrine. So that concept of quote-unquote title is considered more a burden on the actual ownership by Canada, by the Crown, if you will. So, for example, what I get from reviewing this professor's article is that he still sees an underlying title for Canada, but describes it as something less than what is understood as, for example, whole title. But sees that as the first layer. Above that layer, then he sees something he's calling Aboriginal title. I'll see when I read the quote if I got that right. And then he's describing that concept. As I said, for me, I'm the reverse. I'm saying Indigenous nation owners, title, full thing. Then permissions granted to the Crown to exercise partial political sovereignty. So there is a reversal here. I'm not trying to use Canadian domestic law and try to work it into a lawful concept. I say it's bad law. I say that Canada acts as an outlaw nation in many respects and has indeed changed the Constitution in order to create this Section 35 doctrine. In a number of episodes I've described aspects of that. So to be clear, the fact that I'm quoting this professor, because there are certainly areas I agree with him in his analysis. It's important to understand that we're starting from different perspectives in terms of what is layered where. Now, this is Professor Kent McNeil. He used to be the research director at the University of Saskatchewan Native Law Center. He's now, since 1987, a professor at Osgoode Hall Law School, where I attended university for my law degree. And the article I'm referencing is from volume 96, the Canadian Bar Review, number 2, the year being 2018. And here he has on, he says this: the source of the Crown's de jure sovereignty has never been adequately explained by any branch of the Canadian government, judicial, executive, or legislative. Remember, the courts are part of the Canadian government. Perhaps de facto sovereignty has resulted in gradual acquisition of de jure sovereignty domestically and internationally by prescription, but this does not explain how pre-existing Indigenous sovereignty could have been legally superseded by Crown sovereignty without conquest, cession, or Indigenous acquiescence. There has been no conquest. There has been no, if you look at the treaties, and I've spent much of time on that to say, look, you got to look at the boilerplate to have and to hold. That's clearly elements of a lease type arrangement. In other words, a lesser interest in land is being granted by the owners, by the Indigenous nations. So that leaves acquiescence. And this is what is key to the strategy of the Canadian government. Has been and continues, especially under the Justin Trudeau governments. And that is this illusion of, and you can, go to my descriptions on the ANGA, for example, governance agreements, things like that, the membership codes, all that. This concept of trying to manufacture that the people have handed over their jurisdiction and authority to decide to chief and council, and that a chief can then commit and acquiesce to this establishment of Canadian de jure actual legal title. So by staying quiet, that evidences under domestic law consent. Now, people, how can they respond if they don't know what's going on? Well, that's why Canada is conducting all of this in extreme secrecy. The people don't know what's been signed, don't know what's in front of chief and council. They have no legal advice. They have no, even if they do have legal advice, that legal advice is only on, here's how you can become part of Canada. It does not discuss with Indigenous nationals the impact and the fact that their nations are at risk. So this is a very clever ruse, if you will, to try to provide evidence that Indigenous nationals have acquiesced. Going to one other short reference. And he's describing the underlying title of the Crown only amounts to a right to obtain the land if the Aboriginal title comes to an end, either by surrender of the title to the Crown or if the title holders cease to exist. Now remember, he's talking Aboriginal title. I'm talking actual full underlying title. Same point though that applies, that if the title holders no longer exist, obviously they no longer own the land. And this is key to what's being signed off on and what's being dangled and proposed. This is what Jody Wilson-Raybould used to describe as, coming within Confederation, which is an absolute misnomer because, as I've mentioned a number of times, there's no intention to include Indigenous nations, the remnants of that, into some form of confederation. In fact, quite the opposite. It specifically says we're not opening up the Constitution. We're not making room for you there. The place for you is beneath the existing constitutional framework. And that is the only thing that's possible is as is created by provincial and federal legislation to create municipal structures which have there's no municipality in Canada that has any constitutional status. It's merely there at the whim of the province, and in this case would be the federal government. So if, for example, after entering into one of these 10-year finance deals and signing off on quote-unquote self-government, and they got their membership code and they got their First Nation Land Management Act land code in place and all this stuff, and 10 years of that funding is done, and Canada can at that point say, you know what, it's not financially feasible, because remember, all those things are subject to appropriations, which means subject to the decision of the government of the time as to how to spend their money. And they can very well say, this doesn't make sense. You're such a small ethnic minority. One, it doesn't make sense to have government based on, this is racist, to have government based on a race. And two, it doesn't make sense to support these communities that are outside of the large urban areas. So we're just not going to. We're not going to. So, you're on your own. And besides, after 10 years, you're supposed to have some sort of own source revenue in place. But having taken your ownership, having abandoned the ownership and having nothing, you have nothing to leverage. How are you supposed to obtain own source revenue? So it's a very vulnerable position to be in. It is this concept of acquiescing to title being in the Crown, no longer being the title holders because you're no longer the Indigenous nations that entered into those treaties. So these are important. These are important to understand what the game is, what is underway. A lot of people think, well, if I don't vote on something, or I'm not asked, I'm okay, and I can ignore this stuff. Not so, right? Because they're going to, they're going to stack up. There's also the doctrine of extinguishment of treaties to come into play, and I won't get into that here today. But you need to worry about what evidence can Canada present to prove that the treaties have been extinguished. Yes, it's a concept. Well, Canada can provide all these documentations, things signed off, agreements entered into, domestic law creating new legal entities, and say, well, yeah, they're extinguished because the people are no more. The entity that entered into those treaties is gone. In fact, they say they never, because this is part of the mythos of Canada, in fact, they admit they never were able to enter into proper treaties. The domestic courts have said these aren't really treaties. Canada's changed its website to show treaties and Indian treaties because, why? Well, the Indians really weren't sovereign. They didn't have the capacity. They couldn't be seen as, entering into actual treaties. Well, that's just a bunch of bull, right? Because if that were the case, the lawyers for the Crown could not have written those treaties up. They would have had to call them something else, and they would not have contained the concepts and the legal doctrines and terminology that they contain. So that's just a bunch of bull. It is those court cases that have said, these are sui generis agreements, domestic, not international. Well, the international community has said that's not the case after the fact of those decisions of the Supreme Court of Canada, which, remember, the Supreme Court of Canada was created in 1875 by the Liberal Party, and there's lots of questions as to whether it's actually properly a lawful entity. That's for a whole other time. But the point is that it's an arm, as this professor has reminded, it's an arm of government, and I've done an episode on that previously. It's an arm of government, and that arm, both through changing the Constitution twice now for Section 35 and also changing the definition of Indian in the Constitution Act 1867, and setting the stage to say these really weren't treaties, and providing the evidence that, well, even if these were entities that entered into these things, they say they never were, because that's the terminology in incorporating all of those deals being done under Section 35. Because remember, under Section 35, you're admitting that the Crown is the sole sovereign. So remember, acquiescence, okay? You can't be silent. You need to be, even if you don't know, and I'll be helping with this, so not to worry about trying to put something into words. I'll be providing that. To say that, we don't recognize this. It doesn't speak for us. We're still here. And all of these other agreements, again, that will be used as evidence against you to say that not only are you done in now, but you never were. And that's an incredible slap in the face to your ancestors, an incredible slap in the face to you and your next generations. And that's all I have to say.